This is not a drill, and this is not clickbait. Just hours ago, the White House officially signed into law one of the most sweeping immigration reforms we have seen in over a decade. If you hold a green card, if you are on an H-1B visa, if you are a DACA recipient, or if you know anyone who falls into these categories, the next few minutes could determine whether you keep your status or face serious legal complications. I am going to break down exactly what was signed, who it affects, and most importantly, what you need to do before January 30th, because that date is not random. That is when the first wave of changes takes effect, and most people have no idea it is coming. Let me be absolutely clear about something before we go any further. I am not here to scare you. I am not here to spread panic. What I am here to do is give you the verified facts straight from the source so you can make informed decisions and protect yourself and your family. There is already so much misinformation spreading across social media right now, and I refuse to add to the noise. Everything I'm about to share comes directly from the official text of the legislation and statements released by the Department of Homeland Security within the last 6 hours. Now, here is why this particular law is sending shock waves through immigrant communities across the country. Unlike previous executive orders or policy memos that could be reversed with a stroke of a pen, this is actual legislation that passed through Congress and was signed by the President. That means these changes are locked in. They are not proposals. They are not suggestions. They are the new reality for millions of people living and working in the United States right now. So who exactly does this affect? The short answer is almost everyone in the immigration system. But let me break it down into the 3 major categories that will see the most immediate impact. First, green card holders. If you have a lawful permanent resident card, you are now subject to new verification requirements that did not exist yesterday. I will explain exactly what those are in a moment. Second, H-1B visa holders. If you are working in the United States on an H-1B visa, your employer obligations and your personal reporting requirements have fundamentally changed. Third, DACA recipients. If you have deferred action for childhood arrival status, there are critical updates to renewal procedures and documentation requirements that you absolutely must understand before the January 30th deadline. Now, I know what some of you might be thinking. You might be thinking that you have been in status for years, that you have done everything right, that surely this does not apply to you. And I understand that feeling. But here is what makes this law different from anything we have seen before. It does not just affect new applicants. It does not just affect people with pending cases. It applies retroactively to everyone currently holding these statuses. That means the rules you followed when you first got your green card or your H-1B or your DACA approval are no longer the only rules that matter. There are new rules now, and the clock is already ticking. Let me give you some quick context so you understand why this is happening now. Over the past 18 months, there has been growing pressure from both sides of the political aisle to modernize the immigration system. Not to make it easier or harder necessarily, but to make it more accountable, more trackable, and more fraud-resistant. The technology finally exists to implement real-time verification systems. And that is exactly what this law does. It creates a digital infrastructure that connects every major immigration status to a centralized monitoring database. That might sound technical, but what it means for you is very practical. The days of updating your address once and forgetting about it are over. The days of assuming your status is fine as long as you have not heard anything are over. Under this new law, you will be required to actively confirm your status at regular intervals, and failure to do so will trigger automatic review proceedings. Now, before you start panicking, I want to give you some perspective. This law is not designed to deport people who are following the rules. It is not designed to revoke statuses without cause. What it is designed to do is identify people who have fallen out of compliance and create a systematic process for addressing those situations. If you have been living in the United States, working legally, paying your taxes, and maintaining genuine ties to this country, you are almost certainly going to be fine. But, and this is a big, but you cannot afford to be passive about this. Ignorance of these new requirements is not a defense. Missing a deadline because you did not know about it will not protect you from the consequences. So, here is what I am going to do for you in this video. I'm going to walk you through each major change category by category. I'm going to give you specific examples of how these changes might affect people in different situations. I'm going to tell you exactly what documents you need to gather and what steps you need to take before January 30th. And I am going to separate the real concerns from the fear-mongering because there is a lot of both circulating right now, and you deserve to know the difference. If you are new to this channel, this is exactly the kind of content I create. Verified, no-nonsense immigration updates that help you navigate the system without the confusion and without the panic. I read every policy update, every DHS announcement, every USCIS bulletin, so you do not have to. And when major news like this breaks, I get the information to you as fast as possible because in immigration law, timing is everything. Before we dive into the specifics, let me establish the foundation of what this law actually is. The official title is the Immigration Status Verification and Accountability Act of 2025. It was passed by Congress last week and signed into law this morning. The law is divided into 4 main sections, each addressing a different aspect of the immigration system. Section 1 covers permanent residents. Section 2 covers employment-based visa holders, including H1B. Section 3 covers humanitarian statuses, including DACA, and Section 4 covers enforcement mechanisms and penalties. I'm going to break down the sections that matter most to you, starting with the changes that take effect immediately. Let me start with green card holders because this is the largest group affected and frankly where the most confusion exists right now. Under the previous system, once you received your green card, your primary obligations were relatively simple. You needed to maintain the United States as your primary residence. You needed to update your address within 10 days of moving. You needed to avoid criminal activity that could trigger deportation proceedings. And if your card had an expiration date, you needed to renew it. Beyond that, the government largely operated on an honor system. They trusted that you were doing what you were supposed to be doing, unless something triggered a closer look. That honor system is now officially over. Under the new law, every green card holder in the United States will be enrolled in what the legislation calls the Permanent Resident Status Verification Program. Here is how it works. Every 18 months, you will receive a notification either by mail or through the new USCIS digital portal requiring you to verify your status. This verification is not optional. It is not a suggestion. It is a legal requirement, and failure to complete it within the specified window will result in your case being flagged for administrative review. Now, what does this verification actually involve? Based on the text of the law and the preliminary guidance from DHS, you will be required to confirm your current physical address, your employment status, that you have not abandoned your U.S. residency through extended foreign travel, and that you have filed U.S. tax returns as required. The verification process itself is designed to take about 20 minutes online. You will log into the USCIS portal, answer a series of questions, upload any requested documentation, and submit. If everything checks out, you will receive confirmation and your status continues without interruption. But here is where it gets complicated. If something in your verification raises a red flag, and I will explain what those red flags are in a moment, your case gets escalated to what the law calls a status integrity review. This is not deportation. I want to be very clear about that. But it is a formal process where you may be required to appear for an interview, provide additional documentation, and demonstrate that you have been maintaining your permanent resident status in good faith. Let me give you a realistic example so you can understand how this might play out. Imagine someone named David who received his green card in 2019 through his employer. David has been living and working in the United States ever since. He pays his taxes. He has a mortgage. His kids go to school here. Under the old system, David would have had nothing to worry about. But let us say David's company sent him to their London office for an 8-month project in 2023. He maintained his U.S. apartment during that time. He continued paying his mortgage. His family stayed in the United States. But when David completes his verification under the new system, and the database shows he was outside the country for 8 consecutive months, a flag gets raised automatically. Now David has to provide documentation proving he did not abandon his residency. Employment records showing the assignment was temporary. Mortgage statements showing continued payments. Evidence that his family remained in the U.S. If David has these documents organized, he clears the review quickly. If he does not, he could face months of delays and uncertainty. This is why I keep emphasizing documentation. Under this new system, you cannot just say you maintained your residency. You have to prove it, and you need to be ready to prove it at any moment. Now, let me talk about what triggers these automatic flags, because this is critical information. According to the preliminary DHS guidance, The following will cause your verification to be escalated for review. Any single trip outside the United States exceeding 180 days, cumulative foreign travel exceeding 240 days in any 12-month period, failure to file U.S. tax returns for any year since receiving your green card, address discrepancies between your USCIS records and other government databases, employment gaps exceeding 6 months without documented explanation. And here is one that surprises a lot of people. Maintaining significant financial assets, property, or business interests in your country of origin that could suggest divided residence. I want to pause here and address something directly, because I know some of you are already feeling anxious. Having any of these flags does not mean you will lose your green card. It means you will need to provide additional documentation and explanation. The system is designed to identify potential issues, not to automatically punish people. If you have legitimate reasons for extended travel, if you can document your ties to the United States, if you can demonstrate that your permanent residence here is genuine, you will be fine. The people who should be concerned are those who have been treating their green cards as convenience documents, living primarily abroad while maintaining minimal U.S. presence. That is who this law is really targeting. Now, let me address the timeline because this is where the January 30th deadline becomes relevant. The verification system itself will not be fully operational until July 2025. The government is using the next 6 months to build the technical infrastructure and train personnel. However, and this is crucial, the documentation requirements take effect on January 30th. What this means is that starting January 30th, you should be maintaining records as if you could be asked to verify at any moment. You should be organizing your travel history, your tax returns, your proof of U.S. residence. You should be updating your address with USCIS if it is not current. You should be creating what I call your immigration file, a single folder, physical or digital, where all your status-related documents are stored and easily accessible. I recommend every green card holder do the following before January 30th. First, go to the USCIS website and confirm your address on file is accurate. If you have moved and not updated it, do it today. Second, gather your tax returns for every year since you received your green card. If you have not been filing, you need to consult with a tax professional immediately. Third, create a travel log documenting every international trip you have taken since becoming a permanent resident. Include departure dates, return dates, and purpose of travel. Fourth, collect proof of your U.S. ties. This includes lease agreements, mortgage statements, utility bills, employment verification letters, vehicle registrations, and bank statements. Fifth, if you have a spouse or children who are U.S. citizens or permanent residents, gather documentation of those relationships as well. This might sound like a lot of work, but I promise you it is worth it. The people who will struggle under this new system are those who are caught unprepared. The people who will sail through are those who have their documentation organized and accessible. You have until January 30th to get your house in order. Use that time wisely. Now, let me shift to H1B visa holders because the changes affecting this group are equally significant and in some ways even more immediate. If you are currently working in the United States on an H1B visa, you need to understand that your employer now has new obligations that directly affect your status. And if your employer fails to meet those obligations, the consequences fall on you. Under the previous system, your employer was required to file certain paperwork and maintain certain records, but the enforcement was inconsistent at best. Companies could go years without any verification that they were complying with the terms of your H1B petition. The location listed on your petition might not match where you actually worked. The job duties described might have evolved significantly since the petition was filed. The prevailing wage requirements might not have been updated. As long as no one looked too closely, these discrepancies often went unnoticed. That era is now over. The new law creates what is called the Employment-Based Visa Compliance Registry. Every employer sponsoring H1B workers will be required to submit quarterly verification reports confirming that each sponsored employee is still working in the position described in their petition at the location specified and at or above the required wage. If your employer fails to submit these reports, or if the reports reveal discrepancies, your visa status gets flagged for review. Let me explain why this matters so much. Under the old system, if there was a problem with your employment, it often would not surface until you tried to extend your visa or change employers. You might work for years not realizing that your employer had made errors that could jeopardize your status. Under the new system, problems will surface much faster. Quarterly means every 3 months. That is 4 opportunities per year for issues to be identified. Now, here is the part that worries immigration attorneys the most. The law includes what is called a status contingency provision. This provision states that if your employer is found to be out of compliance with verification requirements, your work authorization can be suspended pending resolution. Let me be very clear about what that means. It does not mean you are deported. It does not mean your visa is revoked, but it does mean you may be required to stop working until the compliance issues are resolved. For someone who depends on employment to maintain their visa status, this is an extremely serious consequence. So, what should H-1B holders do right now? First, you need to have a conversation with your employer's HR department or immigration counsel. You need to confirm that they are aware of the new requirements and that they have a plan to comply. Ask specifically about the quarterly verification reports. Ask what information they will need from you. Ask how they plan to handle any discrepancies between your original petition and your current work situation. If your employer seems unaware or unprepared, that is a major red flag. Second, you need to review your own H-1B documentation. Pull out your approval notice and your labor condition application. Look at the job title, the job duties, the work location, and the salary listed. Compare that to your current reality. If there are significant differences, those differences need to be addressed before the compliance registry goes into effect. In many cases, this will require filing an amended petition. That takes time and costs money, but it is far better than having your status flagged for review. Third, and this is advice I give to all employment-based visa holders, consider diversifying your immigration strategy. If you are eligible to begin the green card process through your employer, start that conversation now. If you have other potential pathways to permanent residence, explore them. The more precarious your status feels, the more important it is to have backup options. Now, let me address DACA recipients because this is a community that has faced so much uncertainty, and this new law adds another layer of complexity. First, the good news. This law does not eliminate DACA. It does not create new pathways to removal for DACA recipients. The fundamental protections of the program remain in place. However, there are significant changes to renewal procedures that you need to understand. Under the new law, DACA renewals will now require what the legislation calls enhanced status verification. This means that in addition to the standard renewal application, you will need to provide updated documentation of continuous residence in the United States, updated evidence of education or employment, updated background check clearance, and biometric resubmission every renewal cycle, not just the first time. The documentation requirements are more rigorous than before, and the processing times are expected to increase significantly during the transition period. Here is what concerns me most for DACA recipients. The law also shortens the renewal window. Previously, you could submit your renewal application up to 150 days before your current status expired. Under the new law, that window shrinks to 120 days. And here is the critical part. The law explicitly states that applications submitted after expiration cannot be processed under the existing DUA framework. What this means in plain language is that if you let your DACA status expire even by 1 day, you cannot simply renew. You would need to reapply as an initial applicant, which under current policy is not being accepted. Let me give you an example of how this could affect someone. Imagine someone named Anna whose DACA status expires on April 15th. Under the old rules, Anna could submit her renewal as late as November of the previous year and still have plenty of time. Under the new rules, Anna must submit by December 16th to fall within the 120-day window. If Anna misses that deadline, if she submits on December 20th, her application will still be processed. But if there are any delays and her status expires before approval, she faces a gap in work authorization. And if her status actually expires before she submits at all, she is in serious trouble. The January 30th deadline is relevant for DACA recipients because that is when the new renewal window takes effect. If your DACA status expires any time in 2025, you need to calculate your new submission deadline now. Do not wait. Do not assume the old timeline still applies. The rules have changed and the margin for error has shrunk. So, let me bring this all together because I know I have given you a lot of information and I want to make sure you leave this video knowing exactly what to do. The Immigration Status Verification and Accountability Act of 2025 is now law. It is not a proposal. It is not pending. It is signed, and the first wave of changes takes effect on January 30th. If you are a green card holder, you need to start preparing for the 18-month verification cycle now. Gather your tax returns, document your travel history, organize proof of your U.S. ties, and make sure your address with USCIS is current. The verification system launches in July, but your documentation obligations begin on January 30th. If you are an H1B visa holder, you need to have an urgent conversation with your employer. Confirm they understand the new quarterly reporting requirements. Review your petition documents and identify any discrepancies between what was filed and your current work situation. If amendments are needed, start that process immediately. If you are a DACA recipient, you need to calculate your new renewal deadline today. The window has shrunk from 150 days to 120 days, and there is zero tolerance for expired status. If your DACA expires anytime in 2025, mark your calendar and submit your renewal with time to spare. For everyone watching, regardless of your status, the message is the same. The era of passive immigration compliance is over. This new law requires you to be organized, proactive, and prepared to document your status at any moment. The people who will thrive under this system are those who take it seriously starting today. I will be following this story closely and bringing you updates as USCIS releases implementation guidance. Subscribe and turn on notifications so you do not miss critical information. Share this video with anyone you know who holds a green card, an H1B, or DACA status. The biggest danger right now is people who do not know these changes are coming. Stay informed, stay prepared, stay protected.